Hello and welcome to Courts Today by Live Law. I'm your host Urvashi Chauhan, here to keep you informed with the latest and most important updates from the legal world. As always, first we will cover the top headlines, followed by an in-depth look at each major update. United States Justice Department has indicted Gautam Adani and 7 other senior executives on charges to bribe Indian government officials. Centre has told the Calcutta High Court that state government can take action against IPS-IAS officers serving in their territory. The Supreme Court has given time to Manipur government to file response to the plea challenging inner line permit system. The Delhi High Court has issued notice on Arvind Kejriwal's plea against Cognizance of Enforcement Directorate Chargesheet, and no stay was granted today. In the matter concerning bonded labour, the Supreme Court has asked Union to hold meeting with states, NHRC on interstate trafficking and child labour issues. Uttar Pradesh Court has ordered survey of Sambhal Mosque by Advocate Commissioner on a plea claiming that it was built over a demolished temple. Supreme Court has granted anticipatory bail to a Jagannath temple priest in a money laundering case under PMLA. And the Delhi High Court has refused to quash FIR against Matrix Cellular and others accused of selling substandard oxygen concentrators during COVID-19. The United States Justice Department has formally accused Gautam Adani and 7 other senior executives on charges of bribing Indian officials. It has been alleged that they devised an elaborate scheme to bribe Indian government officials to secure contracts worth billions of dollars, and Gautam S. Adani, Sagar R. Adani and Vineet S. Jain lied about bribery scheme as they sought to raise capital from US and international investors. The US Justice Department alleges that between December 2019 and July 2020, Adani and a US company were awarded contracts to supply solar power to SECI, that is Solar Energy Corporation of India, a PSU. The US company was to supply 4 gigawatts and Adani was to supply 8 gigawatts. SECI's role was to find state distribution companies to purchase this 12 gigawatt supply. However, the high prices quoted in the contracts reportedly made it difficult for SECI to secure state buyers. It is alleged that Gautam Adani, along with Adani executives and officials from the US company, planned to bribe Indian government officials to push state companies into buying this power. This would allow SECI to sign power sale agreements with state companies and in turn enable Adani and the US company to sign power purchase agreements with SECI. Allegedly, Gautam Adani and others offered approximately 2,200 crores to Indian government officials. Approximately 1,750 crores was offered to one official to persuade Andhra Pradesh's power distribution company to purchase 7 gigawatts of power from SECI. The US Justice Department has alleged that these activities violate the Foreign Corrupt Practices Act and the Foreign Extortion Prevention Act, which makes it illegal for people or companies to bribe foreign officials to get or keep business deals. The Calcutta High Court was today informed that Department of Personnel and Training was not the competent authority to take action against IPS, IAS, IFS officers deployed in various states. Additional Solicitor General Ashok Kumar Chakrabarti, appearing for the central government, said so while presenting a circular dated 24th October by the Ministry of Home Affairs, stating that in cases where action is to be taken against an IPS, IAS or IFS officer, the state in which the officer is serving would be competent to take such action. The bench of Chief Justice T.S. Sivangnanam and Justice Hiranyamay Bhattacharya was dealing with the plea seeking registration of an FIR against former Kolkata Police Commissioner Vineet Goyal for revealing the name of the victim of the brutal rape and murder which occurred at the Arjikar Hospital in August this year. Despite clear directions by the Supreme Court to maintain the privacy of the sexual assault victims, the then Commissioner of Police revealed the name of the victim, allegedly resulting in a dereliction of duty. Goyal had been transferred from his post as commissioner after junior doctors who were protesting the state's handling of the incident had demanded for him to be removed. The court today took on record the union's submissions and directed the respondents to file their affidavits in opposition. The next hearing was listed for 23rd December. In the next update, the Supreme Court has granted time to the Manipur state government to file its response in a plea challenging constitutionality of Manipur's inner line permit system, which restricts movement of non-permanent residents in the state. The petitioner, an organization named Amra Bengali, said that due to the ILP system in the state of Manipur, no person who is not a resident of Manipur can enter or engage in business there without obtaining the permit. It may be recalled that the inner line permit was extended to Manipur in the year 2019 following enactment of the Citizenship Amendment Act. The areas under the inner line permit are exempted from the application of CAA. The petitioner argues that extending the Bengal Eastern Frontier regulations to Manipur violates fundamental rights, as it gives the state unlimited power to restrict the entry and exit of non-indigenous people or non-permanent residents in Manipur. The petitioner claims that the harsh ILP system goes against the ideas of social integration, development, and technological progress in areas beyond the inner line. They also argue that it hurts tourism, which is a major source of income for the state. They further state that British introduced the frontier regulations in the year 1873 to maintain control over trade and prevent Indians from doing business with tribal communities. However, even after independence, these restrictions continue, now justified as protecting tribal interests. The bench of Justice Rishikesh Roy and Justice S.V.N. Bhatti today agreed to give 8 weeks' time to the state to file its response. The Delhi High Court has today issued notice on the plea filed by Aam Aadmi Party chief Arvind Kejriwal, who has challenged a trial court order. By the impugned order, the court took cognizance of Enforcement Directorate's charge sheet against him in the money laundering case linked to the alleged excise policy scam. The petition challenges the order, arguing that the 7th prosecution complaint against him is invalid. Kejriwal claims that it was filed without any new evidence, relying on a re-evaluation of old material which is not allowed under law. He also states that ED's further investigation lacked proper authorization since the trial court's approval was not obtained. Additionally, he contends that the court's decision to act on the 7th supplementary charge sheet is legally flawed because it was done without the mandatory sanction under Section 197 of CRPC in this case. Kejriwal's counsel, Senior Advocate N. Hariharan, contended that the 7th supplementary charge sheet was verbatim same as the 6th supplementary charge sheet. He said that it was filed without any fresh material collected during investigation and that even the witnesses were the same in both the charge sheets. At the outset, Solicitor General Tushar Mehta, appearing for the state, submitted that there was a sanction for prosecution and he sought time to file an affidavit in the matter. As Hariharan pressed that the stay application be disposed of today, the court issued notice and listed the matter for hearing on 20th December. Justice Manoj Kumar Ohri granted time to ED to respond to the plea but did not pass any order in the stay application. Let me also tell you, recently the court had issued notice in Kejriwal's another plea challenging maintainability of Enforcement Directorate's complaint in the case. Moving ahead, the Supreme Court bench of Justices B.R. Gavai and K.V. Vishwanathan today directed the Ministry of Labour and Employment to hold a meeting with the states and union territories and come up with a proposal to address the issue of interstate human trafficking as well as the release of immediate financial assistance to the rescued child labourers. Senior Advocate H.S. Fulka, appearing for the NHRC seeking impleadment, urged that 2017 standing operating procedure for the ministry is not being implemented. He submitted that as per the SOP, inquiry should be completed within 3 months. Yet, close to 11,000 rescued children have not been given immediate financial assistance. During the hearing, Advocate Abhishek Jebraj for the petitioners submitted that general guidelines may be laid down by the court so that non-release of financial assistance does not become a recurring problem. In addition, he mentioned that there were specific cases that required consideration. The court today took note of the alarming situation in the state of Uttar Pradesh, where out of 5,262 released bonded laborers, only 1,101 have received immediate financial assistance, and more than 4,000 are yet to receive it. Expressing dismay at the non-release of immediate financial assistance to the rescued bonded laborers, the court said that the issue needed to be addressed by the union as well as the states in a unified manner. A court in the Sambhal district of Uttar Pradesh has ordered an advocate commissioner to survey the Shahi Jama Masjid in Chandosi, and according to the reports, the survey began within hours of the order. The order was passed in response to a suit filed by 8 plaintiffs, including one by Mahant Rishi Rajgiri. He has claimed that the disputed site belonged to an ancient Harihar temple dedicated to Kalki, the last avatar of Lord Vishnu, and that the temple was demolished and converted into a mosque in the year 1526 on the orders of Mughal Emperor Babur. The plaintiffs contest the right to access the property. Civil Judge Aditya Singh gave the order to Advocate Ramesh Chand Raghav to act as an advocate commission. The court has sought a report and response with respect to the findings by 29th November. Stay tuned. The Supreme Court has granted anticipatory bail to Rajkumar Daitapati, a priest of the Jagannath Temple in Puri, Odisha, in a money laundering case under PMLA. The case stems from allegations by foreign nationals against a couple, Kuldeep and Aparna Sharma, accusing them of fraud and cheating involving more than $232 over a property sale. According to ED, Daitapati acted as an intermediary for the foreign nationals, receiving a power of attorney to oversee the case, conclude settlements, and handle funds on their behalf. The bench of CJI Sanjeev Khanna and Justice Sanjay Kumar noted that Daitapati was supposed to deposit 92 lakhs but had only deposited 80 lakhs as proceeds of the crime with the RBI. The top court has granted him anticipatory bail on the condition that he deposit the remaining 20 lakhs with interest within 3 weeks. The foreign nationals will be allowed to withdraw the funds after completing the necessary formalities. The Supreme Court also clarified that granting bail does not imply a judgment on the merits of the case and directed compliance with Section 438 of CRPC for bail conditions. And lastly, the Delhi High Court has refused to quash an FIR registered against Matrix Cellular, its CEO and others accused of selling defective and substandard oxygen concentrators at inflated prices during the COVID-19 pandemic. According to the prosecution, in 2020, the company shifted to dealing in COVID-19 related items and imported and sold products like oximeters, oxygen concentrators, and KN95 masks, making a profit of 40,000 to 42,000 per oxygen concentrator. It was alleged that the oxygen concentrators did not meet WHO guidelines, which require oxygen purity levels of 82 to 96%. Matrix Cellular moved a plea to quash the proceedings. It has argued that the concentrators were legally purchased and sold through its X Factor online platform and distributors using legitimate banking channels. It was submitted that the FIR lacked evidence to substantiate cheating charges and that Matrix operated within the law and paid taxes. Furthermore, it was submitted that the FIR made no mention of substandard product quality and that the said claim was raised only later. But Justice Dinesh Kumar Sharma rejected the plea and said that it was still under investigation whether the oxygen concentrators did not meet the standards set by WHO and the government, and whether petitioner knew that they were substandard or not. Since the investigation is ongoing, the court said that it was not appropriate to cancel the proceedings at this stage. However, it clarified that the petitioner was at liberty to approach the court or appropriate forum after the completion of the investigation. For more details on the cases that I mentioned, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on livelaw. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.